Okay, I'm audible. Hello everyone, I'm audible.
Yes, you are.
Okay. Uh, Good morning, good afternoon, good evening, everyone across the globe. I am Zalalam. It is my pleasure to welcome you all in this insightful session. As internats eager to expand our knowledge and refine our research skills, we are truly fortunate to have this opportunity today. A special and warm welcome to our distinguished guest, Mr. Yadav Rohit, and also Pahal Horizon Winter Research Internship participants. Mr. We are sincerely appreciate your time and effort in joining us. Your expertise and insights into research methods sincerely be valuable for our learning journeys. This session is great opportunity for us to deepen our understanding, ask questions, and gain practical knowledge that will help us in research endeavors. We look forward to engaging and enriching discussion. Then next, my friend Ayushi going to introduce today's guest. Please, Ayushi, continue. Thank you.
Um, Before introducing our esteemed guests, I request all of you to please switch on your cameras because that would be more interactive session with the guests, and the guests will love to interact with you all. So, good evening, everyone. I am Ayushi Gupta. On behalf of Pahal Horizon, extend a warm welcome to our extreme guest, Mr. Yadav Rohit Shankar. We are honored to have you with us today, sir. Mr. Yadav Rohit Umashankar has done his BSc in Physics from University of Mumbai and MSc in Physics from Banaras Hindu University. He is currently a research scholar at IIT Bombay. His research work focuses on light, matter, and interactions at nanoscales. He is trained on fabrications of the sub-wavelength nanostructures using electron beam lithography and also trained on different depositions and the characterization tools, sculpturing thermal evaporator, FEG, SEM, profoliumetry. He has researched and he has uh, done. He has a lot of more achievements, like he has qualified UGC NET JRF in physics, GATE exam, BARC exam, IIT JAM in physics, NNGPE, that is National Graduate Physics Examination. He has attended a lot of conferences in his PhD, such as OPTQ, which he attended in 2023 in Cochin University, Protonics in 2024 in IIT Kharagpur, and ICOPP, International Conference on Photophysics and Photochemistry in 2024 in IIT Bombay. His presence is truly valuable, and we look forward to gaining insights from his experience and knowledges. We are eagerly anticipate an engaging and enlightening session with you. Once again, a very warm welcome to Mr. Yadav. Sir, over to you, sir. You can start the session.
Hello everyone. Am I audible?
Yes, sir, you're
Yeah.
audible to us.
Okay. Uh, so first of all, thank you Ayushi and other organizing members for the kind introduction for me. And it would be pleasure for me to have this interactive session with all the participants here. So without wasting much time, so let's interact. So I will share my slide. Uh, I will. One more point I will need to add. If you have any doubt in between, please stop me and we can discuss in between also. So, could you able to see my screen, right?
Yes, sir, your slides are visible.
Okay. Yeah. So let's begin the discussion here. So basically today I am here to talk a few things about what are patents and uh, how we can take the patent from research which is being done at the university level or the institute level to marketplace. So basically, these things keep a very generally the people in this area have very gap because of not less role. But if you know, then we can get to know how this research work done at the university level can be transported to marketplace. Okay, so we will be discussing about this is the outline of the talk. Yeah, so first we will be seeing what is actually the innovation, how it is done, and what are the general processes involved in that. Then we will see how that innovation can be in the form of technology through various stages can be transferred to marketplace. Then since if the second point needs to be done, then there should be third point be included, because the research and mostly being done at the institute level or the university level, then there should be some feeling between this institute and marketplace. So we will discuss some few things about this. Then we will come to how the patents, what is the role of patent in research, and how it can give you some right and some control over your ideas or over your invention. We will get to know what is the procedure for patent registration, and what are the invention or ideas that can be patented or that is not patented under the law. So we will all be seeing these things under the general consideration. Since I have made this according to the rule or the act according to the Indian law, but it's not specific about the India only, but we will be discussing in general, so that thing is valid in other countries also. Okay, so on the sixth point, we will be discussing what are the general documents required, what you will need to do to file the patent, and what are the benefits of patent filing. And later on, we'll be discussing what are the different patents that had changed the world. I will also show few of the patents that can be done at my lab. Yeah. Okay. 1 second. Yeah. So yeah. So if we talk about the innovation, 1 second, I need to hide this off. Okay. So if we talk about the innovation, so what basically the innovation is. So it is the whenever you have some idea, so you develop that idea, you do some research on that idea, and then that idea or the research is being implemented through some goods or some services, and you offer them to in the like you provide them to the market, and through the market it is provided to the public. So this is the general flow diagram of the innovation process. So initially what you have some idea with you. You need to do some R&D, research and development on that idea. You need to figure out what basically that idea can lead to what invention. So through R&D, you will get to know what are the different flaws and faults of that idea. You will work on that, and after that, once you are developed with the invention and from the idea, then you go to the protection phase. That protection phase is the legal protection that is being provided to your invention, and yeah, that is in the form of patent. So that is given by the government of your respective country. So it has that this protection has some it is by the court of law, it has some rights given to the inventor. So that is also very important in this innovation, whole innovation process, much important. So we will be throughout the discussion, we will be talking about this protection phase only. Then comes the market introduction. So once you have your right with your invention, then you can think about how what is the market value of an invention, or how you can put your this invention into the market at the commercialization level or at the industry level. Then comes the innovation result. Innovation results in the sense the product is being available to the public domain in some result form. So now again this loop closes to the idea, but there is one point here that I want to mention, that is assessment and improvement. So what does basically assessment and improvement means? Like once the idea is being developed and it is in the market, it is not like that more technological innovation cannot be done on the predefined idea or already present, the idea which is already, or the invention which is already present in the market. So even though it is present, more technological advancement or improvement can be done to that particular product, and it can evolve into a new form. Again this whole loop works. So in this whole loop, it is the way how the innovation generally works. So you get to know new research and new technological inventions through this innovation mode. Yeah. So yeah, next comes the, like, once this is a technology transfer process. So it basically the same thing what I had explained. So it is the like generally the movement of technical knowledge or the inventions from one organization to other organization, in between the researchers, or from research institution to private industries through collaborations and like that. So here is the roadmap how this technology transfer generally take place at the society level or at the industry level. So basically the same thing, you have some idea, you do some research, you do some lab testing and validation of your idea, then you develop some market strategy, you get to know whether this invention or the idea has some market value or not. Then you work on the patent strategy of that idea or the invention. If you have some prototype, then you can use that prototype and put it into the market and see whether it has some growth in the industry or not. And the marketing procedure, the licensing is basically related to the patent only. Once you get the patent, or get the granting of the patent, then you have the license for that invention. And then you have the post licensing management. So basically in all this process, if you want to do some innovation or some this technology transfer from one organization to other, so there is a one important one aspect of this is, there should be a very good connection between the industry or the commercial people and the research people. So basically there should not be any gap between not any gap, I mean I can say that there should be some procedure or some method or some following that need to be done to bridge this gap between research and industry. So what is the purpose of this? Why do we need to do this? So if you actively connect this academic research finding with practical application in business world, then uh, it will pay the way to transfer the technology from research institution to marketplace. So through what means we can do this. So if we do these kind of things, if you see the industry academia partnership. So basically in research institutions, uh, there are several projects run by the professors and other project staffs, in which they work on certain projects which have the which is the project which is given by the industrial people. So they have some partnership with them. So this is very a basic requirement if you have a if you want to bridge the gap between research and industry. Other thing is internships and practical training. So in research lab, we generally do the hardcore research and development. Hardcore, I mean hardcore research. But we don't have the practical knowledge of whether these whatever research we are doing, this has some how it can be implemented at the industrial level. So if there is a collaboration between industry and research institution, then through that the students can go from in the research to industry to get some practical training and to some get some knowledge through internships. So yeah, and joint research project, as I explained here in industry academy partnership. Technology transfer offices. This is generally a small unit in every research institution. Uh, like in our institution is also it is there. So this technology transfer offices, this basically sees the intellectual property management. Uh, that means it is the unit which is in the institute which sees about how a research thing can be commercialized and it can be implemented at the industry level. So it also sees about industrial collaboration and funding, entrepreneurship and startups, legal and contract management. So these things, it being seen by these technology transfer offices, it is generally a small unit present at the university or the institute level. There should be open communication and knowledge sharing. So open communication and knowledge sharing is generally the conferences that we visit. So we are the research people, we are the students and or the professors who are doing the research at the institute level. They go to the conferences organized by some other research institute at the international conference or the national conference. There academia people is also coming and industrial people is also there. So they get to know each other what research is being done at the institute level and what industrial requirement is that. So this through open communication and this knowledge sharing, this gap can be filled. So this task is very important if we want to go from research to market. Here are some of the examples that I need to show is that what are the technological innovations generally happened in the recent few last decades. So this first one is the AI, that is the artificial intelligence, which like generally, as you all know, it runs on certain, it is able to make decisions on the basis of the previous data information stored in it. So it is kind of new technological innovation. The Android mobile device that we see, this is the Internet of Things. Internet of Things is generally the all different appliances which can be connected to your device through internet. And 3D printer, this is also modern technological invention. Anything can be made with 3D printers. And here are some of the robotic arms that is being used in the industry at the commercial level production. Here are some examples of 5G and 6G communications. So these are some recent technological innovations that had took place in recent decades. Yeah. So coming to our main part, what is actually the patent and what is the role of patent in research? How it can provide a particular researcher his or her legal right, or how, what is the help of the patent? So basically, let us understand first what is a patent. So a patent is nothing but a exclusive right which is granted by a government for an invention, and it is a product or a process that provides in general a new way of doing something or offers a new technical solution to a problem. So if you are doing some research and you got to know that it is totally new, then through patent, that invention can be protected. It is basically a government law to protect your invention. So what is the purpose of the patent? Here, the main purpose of the patent is to grant investors exclusive right. Investors in the sense who inventors exclusive right to the innovation, allowing them to use and commercialize for a specific period. So yeah, so general purpose of the patent can be described in these 3 points. It protects inventions, is it accelerate innovations, it foster technological advancements. Foster in a sense it supports technological advancements. So if you see what are the words which are related to the patent, this can be seen in this figure. So different words are there which are associated with the word patent. That is the contract. It is a law. So it has some rights associated with it. It is exclusive to the inventor. It gives the ownership to the inventor. It gives permission if a third party wants to use his or her patent, then he or she should have the permission from the patentee and granted property and other things.
Sorry to disturb you, sir. Sir, I wanted
Hmm.
to ask that
Hmm.
how that inventor get to know that his or her innovation is a unique innovation and he should proceed for patent. Like,
Yeah, yeah, yeah. Okay, okay. Please continue. Go ahead.
sir, because in
Hmm.
case of our paper, we get to know that we read lot of papers or publications and get to know that this has been published in this manner. Then we can
Hmm.
modify our content. But how we get to know that this innovation is a unique innovation, we should go for patent. So how get
Yeah,
can we get to know about it?
yeah. So we will come to that point in the coming slides. We will discuss that. Okay.
Okay, sir. Okay.
Okay. So here actually I am getting problem. This thing is being 1 second. I need to drag this here. Okay, now it's fine. Yeah. So what are patent rights protect to? So first we will see what are the patent rights. So patent and intellectual property it helps to prevent third party without authorization is in making or manufacturing. Like what does that mean is that a third party cannot without taking authorization from the patentee, he or she cannot, a third party cannot manufacture on a commercial basis, or he or she cannot sell your patent, or he or she cannot distribute or licensing purpose. So all these things are the comes under the patent law, which protects the patentee from any third party or being misusing your invention. So here the other point is how to patent protects innovations and encourage investments. So generally, why the patent? The question arises why the patent term being associated with the invention. It grants some laws, some rights to your invention, but in the purpose of that is to encourage investments uh, or the investors to see in you. So how they do? To protect inventions by granting investors exclusive rights to their invention for a limited period. There is some period. So we will see what are the key points, how patent encourage investment. Yeah. So yeah, securing market exclusivity. So once patents is being given to the inventor, so he or she has the exclusive rights for 20 years, typically 20 years, preventing the competitors from copying or selling the invention. So you have your market with you. You can put your patent or your invention in the market, and you can take the royalty of that without interruption of the third party into it. Reduced risk for investors. Since patent offer legal protection, it ensures that research and development investment lead to long-term financial gains. This means that if you are doing research and development at the university level, and you have some collaboration with the industry, and industry know that you have a invention and patent had been granted to that invention, then the industry has some insurance that yeah, so it can have some collaboration with you, and it can invest in your research and development. It encourages industrial collaboration. It's the same thing. And there is a competitive advantage. So patent provides a competitive edge, allowing companies to differentiate their products and services in the market. It is a signal of innovation. So if a strong patent portfolio can signal investors that companies actively engage in research and development, which attract further investment. So we'll see what are patentables. Yeah. So now comes we are moving towards your question, which you asked slowly. So what are patentable subject matter? So it's not like that anything can be patented. There are certain rules and regulations that need to be figured out, and then only you can patent something or invention. So first of all, what is that? So it is an invention. What are the patentable subject matter? So it is an invention or discovery that can be protected by patent law. So anything that can be protected by patent law, it's not like that can be patent. So it has to follow certain these things. It has to follow certain rules that is being given here. So yeah. any mechanical devices that work on mechanical principle, software algorithm, but that software algorithm should be something groundbreaking. It should not be like that normal you solve computer algorithm and do something data analysis and like that. That it's not working here. Some medical devices, some new medical devices or drug formula, and some genetically modified organisms. So here I have shown each of like example of through each of these classes. So mechanical, for example, mechanical calculator. This type of calculator is being built in 1980s. And this Google page rank algorithm. This basically rank the, it is an algorithm developed by Google's. It basically rank the particular web page depending upon how many web links are attached to that page. So depending upon that, it ranks that pages. So it is a very complex algorithm. So this thing kind of thing can be patented. Antiretroviral drug, it's kind of a drug which is generally given to mother suffering from AIDS virus, such that that virus cannot be transferred to child if the mother is pregnant. And some genetically modified organisms, if you do some gene modification or at the molecular biology level, then that can also be patented. So, like, what is the basic criteria for
Sir,
patentability?
sorry,
Hmm?
sorry to disturb you, sir.
Yeah,
Sir,
yeah.
one question.
Hmm.
Sir, you said that these are the like some of the subject matters which can be
Hmm.
patentable.
Hmm.
As I am a microbiologist, I am from the Department of Microbiology. So I work
Hmm.
on microbes. If I
Hmm.
search a new microbe, so
Hmm.
that is mandatory that I should work on it and then try to find out a good like a good aspect of that microbe, then only I can patent it, or I can just simply patent it by saying that this is a new strain or new species which has been discovered by me.
Uh, Discovery generally doesn't come under the patent. If you discover new organism that is already present in the environment or something, you just find it out whether this is present. So that discovery will not come under the patent. But if you do some modification with that organism to get some biological help or some kind of gene modification or something which is helpful in some other means, right? You are getting my point. To do some molecular biology on that, then it
So
can be patentable. Hmm.
that means patent is something that that is a benefit for other people. Like we are extracting something from some particular thing and
Hmm.
benefiting other people.
Yeah, yeah, some kind of technological thing you are doing, and it is benefiting in some sense to something which can be taken at the market level to help people or in the form of goods and services.
Okay, thank you, sir.
So yeah, that question what which you had asked, we can see here. What is the basic criteria for patentability? So some novelty should be there. The first step is some novelty should be there in your invention. So the invention must be new and not previously disclosed to the public through publications, patents, or other means before the patent application is filed. So it should not be already researched, already being discovered, or not discovered, already being researched, or already being patented by some other persons, or it kind of thing. Some novelty should be there. The other thing is it should not be non-obviousness. The invention must not be non-obvious to someone skilled in the relevant field. It must represent a significant advancement over existing technologies. So there should be some technological change in that. Inventive step means there should be some technological change and industrial applicability. So the invention must be capable of being used in a practical way within the industry. It can be commercialized in the form of goods and services being to the public domain. So here is the same thing that I mentioned here: novelty, inventive, industrial application, and there are here the fourth point is patentable subject matter. This this matter, whatever the thing you are going to patent, that should not fall under section 3 and 4. Section 3 and 4 generally has some rules and clause. it lists some what are the subjects that are not patentable. Uh, this is a general, I think this is general with general rules and clause that is being followed in other countries also. We will discuss that. So here are that things. So what are not patentable subject matter? So in India, some subjects that are not patentable that I have been listed here. So that come that these all things comes under this section 3 and 4 of Indian Patent Act 1970. So yeah, so the first one is inventions that are uh, harmful. That should not be. So it should not be harmful to environment or health of the public. It's kind of that. Scientific discoveries, mere discoveries of new forms of known substance or scientific principles or abstract theories, it doesn't fall under the patent subject. So as you mentioned that if you know the some kind of microorganism, you are working on it, uh, and you discover that, so that doesn't fall under the patentable subject matter. Methods for agriculture or horticulture, methods for growing plants or raising animals, different methods. If you, for example, beekeeping, this horticulture, beekeeping, and or pisciculture, like fish keeping, these call things different methods that does not fall under the patent subject matter. Methods for treating humans or animals, methods for like it's include that for methods for diagnosing, treating, or performing surgery on humans or animals. So if you discover some now new method of performing surgery or some doing some on animals to treat, that doesn't also falls under the patentable subject matter. Living organism, plants and animals, except microorganisms. So here it is there, except microorganism means the microorganisms you are working on and you are doing some genetic modification on it, then that forms the patentable subject matter. Some mathematical business or mathematical methods or some business methods, that doesn't also falls, or some small algorithms for data analysis, that also doesn't fall under the patentable subject matter. Some computer programs, software codes, or business models. So some creative works, if you are doing some literary, dramatic, musical, or some artistic works, doing painting or something like that, some architectural work, that also doesn't forms under the patentable subject matter. Some integrated circuit layout design, for example, you are doing some IC or something, IC integrated circuit uh, in some electrical instrument, you are designing some IC of that, and you are designing in a new way in the sense you are just changing the design or the layout of that model. That also doesn't fall under the patentable subject matter. And the other thing is traditional knowledge, or the like the knowledge that is coming from the past things. And atomic energy inventions, inventions which are relating to atomic energy, like if you like the invention of atom bomb or hydrogen bomb, that these kind of things are prohibited under the patent act law. So these are the things which cannot be patented. These things can be given, you can find in the section 3 and section 4 of the Indian patent law. Yeah. So now comes the what is the procedure for patent registration? So the pro once once you have the idea, then you do the research and develop a research and analysis of that idea, and now you know that this can be patented. So what is the procedure, or how you will be proceeding to file the patent application? So the first point here indicates that provisional application. So this provisional application generally is given to person. Let's suppose you are not sure whether this my patent work will have impact on the market or not. You know that this is the novel invention, that is true. It has some industrial applicability, but you don't know whether it will give me the full market value, or it will be whether give me some commercialization at the mass level. If you are in some confusion regarding that, then you can file a provisional application in which you will given 1 year patent grant, or no, not patent grant, 1 year of filing the application. You will given 1 year of time. In that 1 year, you can see if your patent has some market value or some market, it can be sustained in the market or not. And within the 1 year, then you need to fill the complete application. Uh, which provides you the 20 years full term patent protection. So these are the general things. Okay. So these are the we will discuss these things. What are the steps in filing the patent? So patent search, patent application filing, drafting the patent specification, patent publication for public opposition, and then patent examination, and then grant of a patent. So yeah, the first step comes here, the patent search. So patent search is why there is a need of patent search first. So the patent search should be done by individual who is going to file for a patent, because he or she should know whether that, first of all, whether that subject is patentable or not, and whether that subject is, or whether that object or the invention is already present, or it is already patented, or some research some information of that patent is being published in some research journal. So that should be totally novel. So because of the novelty, you need to go through a thorough research patent search. Then once you get through that, then you go for the patent application filing. So in which you need to fill out some forms. The form and the form one considers the general information about you and other things. And the form 2 will contain the detailed information about the invention. We will see the detailed information. Detailed information in the sense, mm, we will see in the coming slide. I have written that. Yeah. So yeah, patent specification drafting. So this patent specification drafting basically comes under this form 2. So yeah, what you will be doing actually, it contains the general information of the invention. So what it contains, the form 2, a concise and descriptive title clearly stating the invention's intent. What intent means, what your invention will be doing, or what is the purpose of the invention, and a list of inventors involved in the invention, a reference to a broad field of the invention, in which field the object is being invented, and description. A detailed description should be there of the invention, highlighting its technical details, mechanism, if it works on some mechanical principle, so that how it is working, and some other unique features if you added to that. This may include drawings, diagrams, equations, or other forms of illustration. And claims. The claims means this form also include the legal boundaries of the patent. So what this point indicate that if you are filing a patent, it is not that that patent is applicable everywhere. I mean, in other countries also. So that patent has certain legal boundaries which is governed by the law of that country. So that patent will be applicable in that legal boundaries only, in that geographical area only. So if you want to file your patent, if you want to get your invention to be patented in other countries also, then there is a separate procedure. You need to file international patent application, and through some other means, and that some legal definitions are there for that. So we'll not go much detail in that, but yeah, if in short we can tell that if you want to go for international patents, your patent to be applicable in other countries, then you need to follow a separate procedure. But separate procedure in the sense, you need to fill some other forms also. Then comes the patent publication. The following stage is the publication of patent in the patent journal. It is done in 18 months after the date of publication, and it brings the invention into the public domain. So once you file the application, then the patent publication will come. It will come in it is done in the duration of 18 months after the date of application filing. Then request for patent examination. Once the patent publication has been done, it got to the public domain. Then there will be a patent examination. So within 48 months of applying, a patent examination is requested. An examiner is being assigned to go through the details of the application, and he or she will raise objections against any, if he or she finds any discrepancies in your invention. You need to reply within the 12 months of that. and if that agrees with that, I mean, if both the examiner and the examinee both are agree with that, then it goes for the grant of patent. So only after all the objections are settled by the examiner, then you will you will get a grant of patent to your invention for the period of 20 years. So this 20 years from the date of application date, mm, this 20 years is the general duration given by I have seen for UK and US patent also. This 20 years the general thing duration of patent. But if suppose after 20 years also, if you want to increase your this patent rights legal to you, legal with you, then also you can you need to pay some I mean charges for that to continue your patent rights after that. But if you do not want to get your patent right to be active, then it will be closed, and that invention will be free for the public domain. Then any third person or third party can take the advantage of your invention at the commercial level. So what are the documents required? So yeah, here is the few things I have mentioned here. In this, generally, what documents you need to take. So the statement, one second. The statement and undertaking, statement of yours and its undertaking form that you need to fill that it is from the right of your knowledge that you had not copied or something like that. And power of attorney. Power of attorney means it is the government person. You are handling your all task of patent filing and everything to that person, and he is taking charge of filing the patent. So one form need to fill by this, and your signature should be there. And abstract of the invention, no doubt, abstract of the invention, complete details of the invention, provisional or complete specification, provisional form and complete application form. Provisional form should also fill if you want application form, and fee payment proof should be there. Form 28. Form 28 generally includes that if you are already doing some business in like micro or small at the medium enterprises, you are already have some business with you, then you can fill a separate form to get a rebate of these patent fees through this form. Proof of right to file. This is generally given by the court, that you have the proof that you can file the patent. And priority document is if suppose you had already filed one patent, and due to some means it not got accepted, and like uh, in this patent examination stage, if suppose some discrepancy arises, and it not got settled, then, and you want to file, you had modified that changes in your invention, and again you need to file a patent, then you can fill this priority document, and it signifies that you had already filed the patent earlier, but you are resubmitting the application. So yeah, so what are the benefits of patent filing? So it's one and the same thing. It gives legal protection. It provides exclusive right to the inventor, coupled with the right to use an infringement action in any court of law. If some third person is misusing your patent invention, then you can go against him by the court of law. Market advantage is there. A patent registered product has the market advantage over non-patented products. Patented products are deemed more credible for customers as the registration establishes their originality and innovation. And patent owner can legally can in market advantage patent. If you are a patent owner, then you can illegally form a collaboration with some industry person, and that industry person will give you a royalty, whatever the earning he will make through your invention. So that thing is there, and that comes under the financial opportunities to you. You can sell the patent, or once you sell the patent to some third party, then the right of the patent will not be with you. It will be given to that third party. Or Yeah, this is one thing. Other thing is you can give the license to the third party. So if you are giving the license to the third party, then third party can use your invention, and he will use his market value, his market plan or market strategy to develop your invention at the commercial level. Whatever the earning he will do, he or she will give the revenue, some part of the revenue to you also. So this is a very great financial opportunity to given by the patent and research and development. So yeah. So see here I have mentioned few of the patents that had changed the world. So we already know all these kind of things. So this is magnetic levitation, self-driven car, motorized exoskeleton, iPhone, Bluetooth, drone, 3D printer, GPS system, wireless mobile telecommunication, graphene at the nano level, nanoscale development, solar panels. One thing I have not included in this, that is the light bulb or incandescent bulb, which is invented by Thomas Alva Edison. That is also a very great invention. So in my lab, my lab's name is Ultrafast Optics Lab. Basically, we do research in nanoplasmonics, nanophotonics, and plasmonics. So here are the three patents that is being granted to us. This patent is not registered on my name. I am not included in any of these, but my guide or my supervisor, she has registration with these three patents. So the first is nothing but it kind of fabricating some kind of gold substrate for Raman application. So yeah, and the other second one is for some optical application. Do some birefringence in sapphire crystal. And the third one is some kind of plasmonic or you can say two-dimensional. This MOS2 film is basically a 2D material. So some kind of 2D material research. Okay, thank you.
Thank you, sir. I would like everyone to, if you guys have any doubts or any questions, you may ask, sir. Any
Hello, sir. Can you hear me? Hello.
Yeah, sure.
Sir, while I was studying in my college, I still remember that for filing a patent, it used to cost some money.
Hmm.
So what we did was we did something, and
Hmm.
someone said that after filing the
Hmm.
patent will be in the college's name, okay, not in our
Hmm.
name.
Hmm.
So by doing so, does that create any problem, sir?
Uh, the patent will be on the college name. That is the thing which is being governed by the TTO office. This thing I mentioned here. This
Uh-huh.
technology transfer offices at your university or the college level. If that offices, if this is being everything regarding patent is being governed by or is being managed by your institute or the college, then it will be given to your college name. Yeah, it's like that.
And for the last question, you said
Uh,
that the patents will be different for different countries, right?
yeah,
Is that,
yeah.
for example, let's say I do a patent in US, okay, and
Uh,
someone in another country used my idea. So where
uh,
should we file? Like you said something about courts, right? So this creates a problem. So what in such scenarios, what will happen actually?
uh, in such scenarios in like it's the case of if you are filing a patent in US, so you have the particular for that particular territory of US, you have the legal right to do the market strategy and everything, commercialization of that patent, and you have the patent right with you. You can do anything and in US only. But if some person, if you know that whatever the invention you have done, it has the market value in some other country also. Let's say in India also, it has a great potential of market in India also, and you are not including your patent right internationally, then that person can use your idea at the in India level. I mean, at the India. So in that case, generally what people do, people go for international patent application. So through international patent application, you can cover whatever the territory you want for filing the patent application.
Actually, I'm not still getting the idea, sir. For example, let's say
Hmm.
someone, the watch founder, okay, files a patent,
Hmm. Hmm.
but the watch shows time. But if you
Hmm.
take watch, it has Titan, Sonata, Rolex.
Hmm.
Yeah, it has
Hmm.
different brands, but the idea is same, right? So if I make something, someone can make the same idea, no? Like, what is the in such scenarios? How will patent be useful? Like, I
No,
think,
no. Yeah, I got
yeah,
your idea. You are see that is if you talk about the branding, company branding and copyright issues, then that is a different thing. Like both the companies, Sonata and Titan, both are making the watch, right?
yeah.
And but the brand is different. So patent cannot grant right to the branding values or copyright issues. That is different thing. That doesn't come under the law of patent.
Okay, sir.
So a
Thank
third
you.
person, you got my point.
Yeah, yeah, I got it, sir.
Yeah. So that is like this branding and copyright. These things doesn't come under the patent law.
Okay, sir. Thank you, sir. Thank you.
Hello, sir. I'm questioners.
Hmm.
Uh, my question is, what are some challenges researchers face when trying to patent their innovation?
Researchers uh, challenges for researchers in research and innovation.
Yes, yes.
Uh, Challenges at the institute level, if you like researchers at the institute or university level, if you talk, then challenges are there. There are different kinds of challenges. So the first one, like if you talk about the basic facility requirement, like if you are working in some institute or some university where facility is not of that level in which at the level at which you need to do some innovation, then you will find some challenges there. But if the facility is there, then the challenges will be lower. That is one challenge regarding facility. The other challenges would be in research and innovation would be funding. Funding is also a very challenging aspect. Like if your innovation or research is not solid in the sense have a great potential market value, then to develop that innovation or research, you will get less funding. So these things generally, other things are also there. These two things generally I remember here. So these things we face here in research while here, IIT Bombay. So these are the general things you will find.
Okay, sir. Thank you. And I have a second questions. So,
Uh,
how does the patenting process impact collaboration and knowledge sharing among research?
Patent collaboration uh, that I explain here. Um, yeah, it's the same thing. So if you like, it's one the same thing. Through patent, actually, it one second here it is not. I think this part will explain. One second. Where is that bridging the gap? Yeah, this part. So generally, it bridges the gap between research and industry level through securing market exclusivity, reduce risk for investors, encouraging industry collaboration, competitive advantage, and signal of innovation. These things are there. There are many other things also through which patent helps connecting the gap between research and industry level.
Thank you.
Hello. Any other question? Hello.
Sir, sir,
Hmm.
one of them is asking that can you explain the Form 28 as he didn't understand that?
Okay. Oh, this one. So Form 28 is actually is a form of rebate. Like patent, if you are filing for a patent, so it has some charges associated with it. You need to file, there is some fees. It is not free. So government, if your government is providing some legal rights to you, it is chargeable. So if suppose you are already have some entrepreneurship or some industry, small scale industries, you have like MSME, like micro, small and medium enterprises you are running, so you are already paying taxes to the government on the commercial level, then you under that law or under that form you have some you can tell that some free of charges or some reduced charges for patent filing. Hello, could you get my point?
Or any questions can ask. Otherwise, we can conclude. IOC, can you please coordinate?
Yes, sir. If anyone wanted to ask something else, you can ask, else we can conclude this session.
I would like to represent my thought. Mr. Rohit Umasankarji, very beautifully and very deep information you have given here. And truly believe me that I enjoyed the session too much. And I came to know many more things through your information that you have given just now. So I think all the participants can have benefit from it and do something more and change in their views regarding the patent of this syllabus of the matter. So thank you, Umasankarji. Thank you very
Thank
much.
you, sir.
Wonderful
Okay.
session it is.
Thank you, sir.
Okay. I see.
Yes, sir. Zaran will be concluding.
Okay. Uh, we are going to conclude. Thank you for joining us today for guest talk on the role of patents in research, bridging the research, bridging research and the real world impact. We hope you found the session informative and engaging. We appreciate the time you took to be with us and for your active participation. Special thank you to Rohit Yadav for sharing their expertise with us. If you have any further questions or would like to continue the conversation, please don't hesitate to reach out to us. Thank you again, and we look forward to connecting with you again. Thank you.
So thank you everyone for joining the session. Now we can conclude the meeting and we can leave. Thank you so much. You all can do them. Thank you.
Thank you very much.
Thank you so much. Bye bye.